Yes.
So before the short adjournment, we were working our way through the chronology, and we had just seen the questions that were referred to the CJEU in AXA in October 2010, and I observed that, of course, the CJEU then took matters in a different direction. So the uncertainty that had built up in the UK courts to that point about whether or not triggering was sufficient for the exemption was forgotten about and parked to another day. Next in the chronology is Everything Everywhere. I don't intend to turn this up, save as to say that it's important to recognise that the Everything Everywhere analysis was not actually central to the reasoning on payments and transfers when we look at Bookit and NEC and DPAS. And my learned friend yesterday tried to suggest that actually Everything Everywhere answered it, and look, we can see this from the preliminary observations of the CJEU in that case. And I think it was Lady Rose who made the point that actually the court's judgment proceeded on a different footing and looked at the questions on triggering and payments and transfers, and that's right. And so it is wrong to say that all that Bookit and NEC do is restate Everything Everywhere. Actually, they develop matters more than that. Next is Nordia Panki, which is CJU July 2011. And if I may briefly turn that up, please. That's in tab 10 in the authorities. So we know that SWIFT is a messaging service that transmits payment orders between banks. If I can start off, please, at PDF 685, and I intend just to run through the key passages very briefly. So that's page 685. At paragraph 25, you'll note that the court repeats its ruling in SDC that a transfer is a transaction consisting of the execution of an order. The fact then, moving on to 29 and 30 in the judgment, the fact that international payments would be impossible without SWIFT services was insufficient. So that's a combination of Nordia Panki's submission at paragraph 29, at which the CJEU rejected at paragraph 31. SWIFT merely transmitted data, it didn't alter ownership rights, which was done by the financial institutions themselves in the context of their legal relations with their own clients. And that you get from the Court of Justice at 32 and 34. So that's 32 and 34. And then at 35 through to 38, the court also dealt with Nordia's argument in relation to the fact that SWIFT assumed financial responsibility for the correct and secure transmission of financial messages. And what the court essentially is saying there is, yes, but if you, SWIFT, don't perform your role properly, you may be liable for damage. Damage is caused by defective or delayed messages, but that's not the type of liability that we're concerned with in relation to the payments and transfers exemption. And I think it was a point that my Lord Sales made yesterday. Liable for damages is not the sort of liability that we're talking about here. So that's 35 through to 38. So in short, Nordia makes it clear that merely transmitting an order for payment isn't sufficient to be exempt, even though SWIFT was an essential part of the payment or transfer of funds in the sense that it was indispensable. That's insufficient to make supplies exempt. That's simply a repetition of the general point that came out of SDC. Now, the judgment does not say this in terms, but we say it's implicit that simply initiating an automated process that triggers the transfer of funds isn't sufficient to qualify for exemption. None of that is controversial. All of that is simply an application of SDC. Just picking up then the next point in the chronology, by chance, December 2011, AXA Court of Appeal Hearing 2, so AXA has now come back to the Court of Appeal. And just to say, of course, notwithstanding that Nordia Pankey's now been released by the European Court, because AXA has been sent off in a completely different direction by the European Court, the Court of Appeal doesn't consider Nordia Pankey because it's now concerned only with debt collection. Nothing happens domestically for about 3 years or so, but the next relevant case to look at is now Bucket 2 in the first tier. And the reference to the CJEU was in February 2014, and we have the first tier's decision making the reference. And if I could show you a few paragraphs in that, please. Beginning at page 1488. And what I want to say is this. The first tier is now uncertain as to what to do with the case law. In particular, what is the...
Sorry, I'm curious to do with...
What to do with the case law, in particular now that Nordia Pankey has been released. How does Nordia Pankey affect the picture? And it makes a reference again, as we'll see, on essentially the same basis, asking essentially the same sorts of questions as the Court of Appeal did in AXA. So it's having another go now. And if I could ask you, please, to go to paragraph 99, and bearing in mind, of course, that Bucket 2 is materially the same as Bucket 1, which the Court of Appeal has already decided in the taxpayer's favour, now the Revenue is back trying to get a reference. Counsel for Revenue is Mr. Beale. He relied heavily on Nordia Pankey, the new CJEU judgment that's entered into the picture. At paragraph 100, Mr. Hitchmo, who is counsel for the taxpayer in Bucket 2, submitted that Nordia didn't move matters any further forward. If I can ask you, please, just to move on to 105, the first tier observes that Bucket, so this is Bucket 1 Court of Appeal, is binding on me unless it's contrary to subsequent CJEU authority. I cannot say that it's inconsistent with subsequent authorities, nor can it be distinguished on its facts from the present appeal. At 107, you'll also see that counsel for Bucket relies on what at this stage had happened, a decision in favour of the taxpayer in NEC, which involved very similar issues. And in NEC, the first tier decided that the taxpayer one allowed the appeal. HMRC then appealed to the upper tribunal. And then if I can just direct you to paragraphs 110 through to 114. Where you'll see at 110, the submissions that HMRC made, bearing in mind that now we have Nordia Pankey and there's uncertainty. At 111, HMRC is now arguing that the CJEU set out the principles in SDC and the CJEU has given a consistently narrow interpretation. But in contrast, UK domestic tribunals and courts have given a consistently wider interpretation. So which is it? Which is correct? At 112, the first tier says, well, in my view, Mr. Beale's submissions in the light of Nordia are at least reasonably arguable. I'm not satisfied that I can identify the scope of the exemption with complete confidence. And then at 113, it's not clear to me as a matter of principle what factors distinguish the provision of financial information without which a payment would not be made, but which do not fall within the exemption such as Nordia, or data handling services which have the effect of transferring funds such as STC. And then 114 is relevant. In reaching this conclusion, I'm fortified by the fact that the Court of Appeal, in making a reference in AXA, all appear to have had, and the High Court and Everything Everywhere all appear to have had the same reservations as to the scope of the exemption. So pausing there, what we then have is, because of the uncertainty between the European and the domestic case law, fortified by what was said by the Court of Appeal about the uncertainty in AXA, and also the High Court in Everything Everywhere. We don't have a copy of that decision. We don't need to look at it. The first here makes the reference. Some months later, and we don't have it in the bundle, but it's on a similar footing, the Upper Tribunal in NEC makes a reference in January 2015 on materially the same terms. And the CJEU decides both of these cases in May 2016, and its decision is in effect that actual execution is required to make the exempt payment service. Giving instructions isn't sufficient, even if they're essential in the sense that no payment would be made without them, and even if those instructions automatically trigger the payments. In other words, the Court of Appeal was right in its doubts about AXA. So if we can please turn up, this is now the Court of Justice in Booklet 2. Please can I ask you to turn to page 727. And my learned friend showed you paragraph 38 yesterday, so I'm picking it up in the judgment where the court is saying the court has previously held that a transfer is a transaction consisting in the execution of an order for the transfer, etc. So 38 is essentially setting out paragraph 53 of SDC, those familiar sentences. There's a discussion of the principles that arise directly from SDC in 38, 39, and 41. And if I could ask you please to go to 44, which is an important paragraph that my learned friend skipped over. The court says this: in this case, so in Booklet, it must be observed that, as is apparent from the description in paragraph 31 of this judgment, a card handling service, such as that in issue in the main proceedings, has the effect of leading to the execution of a payment or transfer, and such a service may be regarded as being essential to that execution. So it's a prior indispensable stage. Given that, as is stated in the order for reference, it is the transmission of the end-of-day settlement file by the service provider to its merchant acquirer that triggers the process of payment or transfer of the sums concerned. So pausing there, what was happening here is Booklet was sending off an end-of-day settlement file. That file was the very thing that triggered the process of payment when it was received by the merchant acquirer. And the Court of Justice also notes that the only payments or transfers that are in fact executed are those for which the necessary information is included in that file. And that file is a file that Booklet has composed. Booklet sends it off. Sending it off triggers the process carried out by another operator. The process carried out by the other operator is the actual execution of payment. And so we can see from this, when that paragraph is read alongside the questions that the Court of Justice has previously been asked, this repeated notion is triggering the process enough. In rejecting Booklet's arguments, the Court of Justice here is rejecting the notion that simply triggering a process that someone else executes, where someone else executes the payment or transfer, that step of triggering the automatic process is not enough. And that's why Booklet services were taxable. And we can see the analysis in large part, I think my learned friend has taken the court to already. At 45, the mere fact that a service is essential is not enough. at 47.
And sorry, it's just worth noticing they're citing their SDC paragraph 65, so
Yes.
attributing it to it, the importance you say.
Exactly. And so the notion that triggering is not enough is what comes from SDC paragraph 65. The mere fact that it might be an indispensable part is not sufficient of itself. And then 47 and 50, I think my learned friend showed the court yesterday, so I won't reread them. But bearing in mind the chronology of the cases, what is clear at this point is the domestic courts have gone off on a tangent. The UK courts are now in a world where triggering a process which is automatic and which can't be interfered with once it's started is an exempt supply, even though it's actually someone else that's executing the order for payment further down the chain. And that has now been conclusively rejected, we say, by Bucket and NEC. And the reason for taking you to through the chronology and the failed attempts and the questions asked previously is because all of this is building up and is part of the background to the court's decision in this case. What I'd like to do now, please, is move on to the last piece in the puzzle, although I suppose we say there is no puzzle because it's been conclusively solved at this point, but it's the judgment in DPAS, which is July 2018. And you'll see from our chronology, it so happened that we had the first-tier tribunal hearing in March 2018, so at the time of the hearing, neither the opinion nor the judgment in DPAS existed. And so the first-tier tribunal was working off the previous position up until this point. I should also add, and this comes through in the judgment, unlike in Bucket and other cases, HMRC was not, because of AXA, HMRC was not specifically arguing that payments and transfer exemption did not apply. HMRC's case was only focused on debt collection, and we simply adopted a neutral stance.
Because of paragraph 28 in AXA.
Exactly, because of AXA, exactly. And so in adopting that neutral stance, we didn't have the benefit of either the opinion or the judgment in DPAS. The opinion comes out, and from memory, neither party was asked to make submissions on it, and that's not a criticism of the first tier, that's simply the way the first tier hearing proceeded. Although the first tier of its own accord noted, I think, that the opinion existed, and the judgment of the CJEU came out sometime after. So please can I ask you to turn then to its authorities tab 14, starting off with the questions that were actually referred in DPAS, if I may, and that is at page 766. And at this stage, what DPAS has done is it has acknowledged that it lost AXA because of the debt collection point. It has rearranged part of its supply so that, in fact, it's now providing services to patients as well. And it now says, now that we're providing supplies to patients, that can't possibly be a debt collection service. So now, surely, based on AXA, we must win. And the questions referred are set out at paragraph 26, page 766. And if I could ask the court just to read question 1, please. And so in question 1, as you can see, I think it's the upper tribunal at this stage is in a real position of uncertainty. Well, what do we do? Is it AXA? Is it book it? What's the right answer? And this is important to the upper tribunal because, as you can see from question 2, because of the reconstruction, the upper tribunal is no longer certain that this can just be knocked out on the debt collection argument because the supplies are now being made to different people. So question 1 takes on a real significance, and it brings the potential conflict in the cases of the European Court to the foreground, albeit nothing was said in AXA that actually gave clear reasoning as to why Bucket and NEC were wrong. It was simply the outcome and the way that the court decided the question in that case. So if I can go through, and I don't think that the court was shown the Advocate General's opinion, but this is quite important given the similarities between DPAS, we say, and this case. So if I can ask the court please to start with page 750, starting off in the Advocate General's opinion, paragraph 12. And I appreciate that the court may have pre-read this case already, so I'll just go through the relevant paragraphs and make my submissions on them quite briefly. So paragraph 12 of the opinion is where the Advocate General notes that the manner in which the direct debit operates is materially identical to that described in AXA. And that's important because when we look at the Court of Justice in AXA 7 to 11, we see that Denplan, in fact, uses the back system in materially the same way as Target. And if I could ask you, please, just to turn very briefly, because those paragraphs aren't repeated, so we just have to look back at them. It's page 655. So 655 is paragraph 7 to 11 in AXA Court of Justice. And without going through it in detail now, when the court reflects on these later, you'll see it's materially the same way that Target uses the back system. In particular, paragraph 9, I would draw the court's attention to. Which is all about the information that Denplan transmits to BACS, which starts off the automatic process. So, bearing those facts in mind then, could we please go back to the Advocate General, paragraph 22 now, which is page 752. So that's simply setting out the questions referred. And so far as the Advocate General is concerned, applying the court's previous case law, it was clear to him that DPAS didn't make exempt supplies. Moving forward to Advocate General paragraph 32, please, which is page 735. The Advocate General notes the first time the court was asked to consider the exemption was in SDC, and the court made it clear in SDC that the supply in question had to change the legal and financial situation.
Excuse me, did you mean 753?
753.
I'm sorry, I misspoke. 753. Paragraph 32, 753. Moving down to 36, the Advocate General notes that AXA is in fact an outlier. Moving on to 40, in the Advocate General's view, DPAS's services fall precisely within the sphere of physical, technical or administrative services. And just to pick up to Lady Rose's question earlier in the morning, There was a discussion about SDC and the notion of what's a physical and technical, and I think the telephony services, and I said that, well, at the time of SDC, bearing in mind the context of that case, that was the low-hanging fruit, they were obvious. We can now see by the time we get to DPAS that actually included in that mix is exactly the sort of service that DPAS provides. Moving on to 41, you'll see how the Advocate General describes DPAS's services as requesting from a bank via a direct debit mandate that money be collected from the patient's account and paid to it, and then from its account to dentists. At 42, the Advocate General notes the fact that DPAS's services were essential isn't sufficient, because at 43, DPAS's services did not in themselves result in the legal and financial changes. And 44 is key. So this is over to page 756. DPAS doesn't carry out the transfer, rather it asks the financial institutions to do so, so its involvement comes at a prior stage. And at 45, the fact that DPAS obtained the authority to request the transfer can't transform that preliminary step into a transfer. At 46, it's the financial institutions that carry on the transfer. At DPAS merely administers, and we say that's the same position that Target occupies. And I spoke at length this morning about the various tiers in the system and BACS and the Bank of England and the role that the banks played, and Target is not performing any of those, just as DPAS was not performing any of those roles. Nor was it a subcontractor to any of those parties who were actually involved in making those transfers. Up until this point, the Advocate General has simply been applying the CJU's judgment and reasoning that emanates purely from SDC, and it's distinguished it from ATP along the way. Now, from 47 onwards, here the Advocate General notes, and before I carry on, so that underlines our submission that all that DPAS is an application of SDC. It's not changing it, it's simply applying it. And so all that the Court of Appeal was doing in the equivalent case of Target is applying the core principles that come out from SDC. There is no change that disrupts the entire financial system in the UK, as my learned friend would have it.
There may be if people had based their businesses on what the Court of Appeal here had said in FDR and Bookit number 1 and AXA in the High Court, because they would have thought they were exempt.
So when we get to paragraph 47 of the Advocate General, then the Advocate General says that his reasoning is confirmed by Bookit and NEC. So I would say, in response to your lady's question, the change, such as it is, came about with Bookit and NEC. So that's some years past. The Court of Appeal did nothing radical in this case. And at 47, the Advocate General also notes that, in his view, Bookit and NEC were more closely linked to transfers than those in AXA and DPAS. So actually, Bookit is closer to getting exemption than AXA and DPAS in his view. At 49, he emphasises the reasoning that Bookit and NEC's supplies did not itself result in the legal and financial changes. And at 50, Bookit and NEC simply concerned an exchange of information. Importantly, at 51, it is clear that if the exemption were to apply to DPAS, that would be an extension in the case law, since DPAS is merely performing a step prior to the exempt payment or transfer transaction. At 52 to 55, there's further reasoning why the Advocate's conclusion is consistent with the finance exemption more generally, and the high-level objectives of the finance exemption. And at 55, the Advocate General concludes that the exemption is not available since it does not itself result in the legal and financial changes. At 56, the Advocate General notes that AXA is not consistent with the previous and later case law of the Court of Justice. So that's my point about AXA being the outlier. And then at 57 through to 65, if I can just summarise this, having noted that the services at issue in AXA and DPAS were the same or very similar, the Advocate General went on to discuss the CJEU's reasoning in AXA, rejecting the possibility that the court had intended to broaden the scope of the payments or transfers exemption. So AXA was simply an oversight or a misstep. It wasn't intended. And the point that emanates from these paragraphs is not only did the Court of Justice not establish any new criteria in AXA, but it reverted to the prior formulation in Bucket and NEC. And from 66 onwards, the Advocate General then turns to consider the debt collection exclusion. And the way the Advocate General puts it, which touches slightly on one of the points my learned friend made in relation to debt collection, is to say, well, if I'm wrong about payments and transfers, then I have to look at debt collection. And the Advocate General's conclusion on debt collection was that this was ultimately a debt collection service. And the reason I make that point is because my learned friend constructed this image of a fence, I think, to use his language, between payments and transfers and exemption, and debt collection. And he said there shouldn't be any overlap. It's wrong to suggest that debt collection is a carve-out. But you can certainly see from here the Advocate General's view. Debt collection is a carve-out. We only look at debt collection if the service would otherwise potentially be within the scope because it's a payments or transfer service. And that point is repeated by the Court of Justice, and I'll pick that up in due course. So in short, DPAS's services were taxable, either because they're not payments or transfers in the first place, but if they are, then they're nevertheless excluded because of debt collection. If I can move on then swiftly to the Court of Justice, the Court's judgment, please. And if I can pick this up from page 736 onwards. So paragraph 10, the Court recognises the express similarity between DPAS and AXA. And the reason for restating this is because the piece about how DPAS interacted with BACS is set out in the AXA judgment. It's not repeated anywhere in the DPAS judgment.
So, I'm sorry, so it was 736?
763.
Thank you.
And this is paragraph 10, where the Court recognises the express similarity between this case and the facts in AXA. 11 through to 18, the Court sets out the changes DPAS made to its arrangements. Now, if I could alight briefly on paragraph 23, please, which is on page 765. At paragraph 23, the Court summarises the upper tribunal's uncertainty about reconciling Bucket and NEC on the one hand with AXA on the other hand. And I say that you can also take from this paragraph, if you look at the words between G and H, the sentence starting furthermore, assuming that the supply of services at issue comes within the scope of a transaction concerning payments and transfers, then the Court, so being the upper tribunal, is unsure about the debt collection carve-out. So I appreciate that here all the Court is doing is reciting the upper tribunal's uncertainty, but nowhere in the judgment does the Court of Justice say, oh, but hang on a minute, your assumption is wrong, because they're two completely separate things. So, and like I said, the point is made also in the Court of Justice in AXA. So 24 onwards sets out HMRC's view that Bookit and AXA show that a taxable person who uses other financial service providers for transfers between bank accounts does not carry out transactions concerning transfers. And that's important because it shows that the CJEU had this question of outsourcing well in mind. It's also important because that's an accurate description of the analogue role that Target plays. So Target uses the BACS and the banks to effect transfers and payments. It isn't carrying on a role that they have delegated to it. 26 is the question from the Upper Tribunal. 27 sets out the transactions. We say they're materially the same as the transactions that took place here. Save that here, of course, the money moves straight from a borrower's bank to Shawbrook's bank. There isn't this intervening stage of Target collecting the money like DPAS did and then moving it on again. But that shouldn't make any difference. 28 through to 35 is yet again the familiar passages from SDC and the subsequent case law. And then at 38, the court expressly approves 35 and 39 of the Advocate General. 40 to 41 are key. DPAS does not itself carry out the transfers or the materialisation in the bank accounts. Rather, it asks the financial institutions to do these things. So that's a key point of distinction, and we say Target is in an analogue position to DPAS. Moreover, at 41, the court notes that it doesn't require materialisation in both bank accounts, but the point is that DPAS didn't alter any bank accounts itself. And 41 clearly envisages that it's the financial institutions themselves that carry out the transfer in this sort of arrangement. At 42, the court approves Advocate General 51 that DPAS undertook simply a prior step. 43 repeats the familiar language that the mere fact that DPAS's supply is essential isn't sufficient. 44 is important because it's another point about liability. DPAS isn't responsible for the failure or collection of or cancellation of the direct debit mandate. And that's the same as the position here. Target reconciles its accounts at the end of the day. It removes failed payments. It isn't the case that Target basically makes the legal and financial changes up front and then accepts itself the liability of those payments being cancelled. At 48, the court approves what the Advocate General has said at 59 to 63 about the AXA judgment. And that's important because here the CJEU is confirming that in AXA, the CJEU did not specifically apply the SDC test. So I can say that again. The court in DPAS is confirming that the court in AXA was not applying the SDC test. That's the effect of reading 48 with 59 to 63 of the Advocate General that the court here is approving. And then at 50, that leads the court to say that AXA cannot be relied on as supporting the exemption on the grounds of payments or transfers. So that brings me to the end of the chronology through the cases. In the interest of time, I do not intend to go to card point. If I can simply refer you to it's paragraph 90 of the Court of Appeal, PDF 208, which sets out what we say is a correct discussion of card point and its relevance to this case. It has no relevance to this case. And I adopt our written submissions in relation to card point, and that appears in various places in our written case.
Does the court or the Advocate General, any of these cases, rely on your point about you've got to construe it narrowly so it doesn't overlap with management of credit under little b?
Yes, it does. Can I just
If you're going to come to that, that's fine. They don't. It doesn't seem to be at the forefront of their arguments, I'd say. But
at all stages in all of these decisions, the court always reiterates. It's the case that no one can pronounce, but the general principle that exemptions are to be construed narrowly. And it's, one second, this was covered in the Court of Appeal at paragraph 17, referring to one of the UCJ cases. So actually it may be a convenient moment just to look briefly at that, please. So forgive me, I just need to find the page.
179, I think.
Yes, thank you, 179. In fact, could I ask you just to read paragraph 17 and I'll make my submissions on it, please.
Sorry, 1717.
So it's page 179 and it's paragraph 17. And so the underlying CJU authority for that is the Headchrist case, which I wasn't planning to go to expressly because the references are all in the Court of Appeal's judgment. But in this paragraph, the Court of Appeal is saying two things. First of all, it's pointing out the timing. Management of credit by all comers was exempt for a period of time. Then it was specifically carved out, so management of credit from 1991 onwards was only exempt for the grantor of credit if the management was being done by the grantor of credit. And then the more general point here, this has implications for the approach to the construction of the exemption, so the finance transfers exemption, because as the CJU has made clear, where there is a specific exemption for the management of credit but only for the person granting the credit, a broader exemption, i.e. payments and transfers, must not be interpreted so widely as to underline the deliberate choice by the legislator of kicking out of exemption the management of credit other than by the grantor. So I think if I've understood my lady's question correctly, that paragraph summarises the answer. Yes.
But I think very specifically, in answer to my lady's question, the other authorities you've taken this to did not actually highlight this point. They make the strict interpretation point, for instance, in SDC paragraph 65, booklet paragraph 45, but really as a standalone, that it's strictly to be construed, hence the focus down on the transfer itself, rather than buttressing that point by reference to para B.
Yes, so if I can say this, at this time I cannot point you to a specific paragraph, and the reason I put it that way is because in the back of my mind I think that the AG in SDC might have said something, but
well, never mind.
I don't want to say it as a hard no.
Was about a different. That wasn't about these exemptions. This particular exemption.
It was making the same point.
Yes. Yes, thank you.
So that's the end of the chronology, and we say that the following points emerge from that. First of all, this debate about whether instruction is sufficient has existed ever since FDR was decided, because all of the subsequent domestic case law, you have the sense of, well, is this in fact accurate? Should we make a reference? We're not sure about this. HMRC's position throughout has consistently been that instructing isn't sufficient. We say that the UK took a wrong turn very shortly after SDC, potentially because the concepts in SDC were broad and they were new, and we've taken a long time going through the paragraphs this morning, with FDR and then Bucket 1 and then AXA High Court. But by April 2009, the UK courts themselves are first expressing doubts over whether mere instruction that triggers an automatic process is sufficient. And we see eventually, when that question is answered by the Court of Justice, HMRC's position throughout is vindicated. So that's all I wanted to say about the meaning of execution, the relevance of backs, the role that target plays in the messaging chain. I want to turn very briefly, please, to negotiation. So as you'll recall, the exemption is member states shall exempt transactions, including negotiation concerning payments and transfers. And for the first time before this court, my learned friend says, negotiation. Well,
he didn't make that point orally.
He didn't make that point orally. But what I would like to draw your attention to is CSC, please. And this is the case from December 2001 that we skipped over in the chronology. So very briefly, CSC concerned call centre services to financial institutions. It provided information and processed investment applications without providing advice and without completing transactions. I'd like, if I may, just to turn to page 626, because we'll see at 626, it's Advocate General paragraph 28, which starts on the preceding page, when read together with the corresponding footnote P. And just to make the point at the end of paragraph 28, so over the page 626 by little a, what Sun Alliance was trying to do in this case was to mischaracterise SDC. We'll see the Advocate General in that paragraph rejects that and says the exemption applies to activities which, involving a change in the legal position, genuinely perform the function of the tax-exempt operation, which means they actually constitute that operation. And so that is the way the Advocate General, in the case immediately after SDC, interprets SDC 66. And the last point that I'd like to show the court too, please, if I may. CSC was also a case that was referred by the UK. And if I can ask you, please, to turn up page 630, paragraph 12 of the court now. This is noting the outcome in the VAT tribunal. The VAT tribunal had held that exemption extended to necessary preliminary stages in the context of the issue and transfer of securities. So that's what the VAT tribunal had held. That is rejected by the very fact that the CJEU reaches the opposite conclusion that what CSC does is taxable. But you already have here this notion of necessary preliminary stages. The Court of Justice says, no, that doesn't attract exemption. And the only other point that I want to make in negotiation is in CSC, the taxpayer said, well, if necessary preliminary stages don't fall into the exemption, the payments and transfers piece, we rely on negotiating, which is the same argument that my learned friend makes here. And the Court of Justice tells us very clearly at 39 through to 40 that the negotiation argument is also wrong. 39 through to 40 starts on page 633. Because, and in a nutshell, negotiation is doing everything to introduce two parties to a contract and do everything necessary to conclude that contract. Now, Target, of course, comes on board only after the principal sum has been lent down. So whatever Target is doing, it can't possibly be doing negotiation, because the negotiating has already ceased when the loan is drawn down. And that's in the context of shares. And in our written case, we've referred the court to Volker Ludwig, which is dealing with the same point in relation to granting a negotiation of credit. We haven't found a case that is dealing precisely with negotiation of payments and transfers, but what I would say is negotiating crops up in insurance, in shares in CSC, in credit in Volker Ludwig. It's always the same concept, and my learned friend has not taken you to any authority to suggest that in the payments and transfers exemption, suddenly negotiation means something else. My learned friend didn't develop orally the submissions he made in writing in relation to actual potential transfers. So if I could simply say that we deal with this at paragraph 60 sub 5 of our written case, which is PDF 155, and the word potential crops up for the very first time in a case that's all about underwriting guarantees, so SEB, the SEB case, which concerns underwriting guarantees whereby SEB undertook to acquire shares issued by a third company which weren't subscribed by the end of the subscription period. And that's a very specific example where the court says, well, yes, we accept that merely giving an underwriting guarantee on day one, you're not actually buying the shares on day one because it depends on what happens at the end of the subscription period. But the reference here to potential is those shares will be bought at the end of the subscription period by the same company that executes the potential transfer on day one. So it's not a case where you've got one company doing one thing at a prior stage and someone else actually executing the transfer. We don't say, I don't want to spend any time on this, but there's no magic in the word potential. It doesn't bring in prior acts, and if it's something the court is concerned about, I'd refer the court to SEB, because that deals with precisely what is meant by potential very clearly. I'd like to turn, if I may, on to loan account entries. We deal with this in our written case at paras 72 to 73. And I think the court already has the point that I intend to make in relation to ATP, so I'm not going to labour it.
So this is what has been referred to as the ATP point?
The ATP point, exactly. So Target is arguing that the debits and credits it makes in its loan account ledgers themselves alter the legal and financial position as between Shawbrook and the borrowers and are equivalent to those in ATP. If we could please just turn up the judgment in ATP, starting on page 718. And if I can just explain what we say is happening in ATP. So employers are under an obligation to their employees in order to make pension contributions. So there's a liability at the start. In order to discharge that liability, the employer will deposit a lump sum with ATP. And that lump sum will not be a single payment per employee. It will simply be, at the end of this year, our commitment to all of our employees is to the tune of 100. We deposit 100 with UATP. At that point, the employer has given cash to ATP, but nothing has happened to then subdivide those amounts further and distribute the contributions, if I can put it like that, between the individual employees. What ATP does is it operates its own accounts that makes that division. And the upshot of ATP putting that into its accounts is if on day one my employer is obliged to make a contribution of 10 in relation to me, the act of ATP debiting and crediting its accounts and effectively in its accounts allotting 10 to me is now to discharge my employer's obligation to make a contribution of 10, and that now my rights as employee lie vis-a-vis ATP to invest, whatever the case may be, under the terms of the pension scheme, and in due course to pay me the money and the fruits of that investment and so on. So ATP was performing a very specific function. Its accounts had the effect of extinguishing the employer's obligation to make a pension contribution, and it fructified, if you like, ATP's obligation in relation to that money as scheme provider. And that's the relevant change that the Court of Justice is talking about at paragraph 82. So that's page 718, paragraph 82. And that's why those credits aren't purely technical. They appear to establish the rights of the pension customers vis-à-vis pension funds by transforming the claim held by a worker vis-à-vis his employer into a claim held by that worker vis-à-vis the pension fund of which he is a member. And this wasn't a case where ATP deposited the money into bank accounts for each individual employee. It was simply a case of the credit being affected by the credit entries that ATP made in its accounts. And then at 83, the court says, well, it's for the National Court to identify what was exactly what was happening with ATP. Now, we say the position here is very different.
So does HMRC accept that scheme providers who do a similar sort of thing here are exempt on the basis of ATP?
Well, if it was the case that a scheme provider did, as a matter of fact, the very thing that is talked about in 82, then the conclusion would follow. I don't have any knowledge as to what scheme providers actually do in the UK, and whether there are sub-trusts or different accounts or quite... I just couldn't tell you about the detail. So no part of our argument challenges what the Court of Justice said in ATP. And you can see why what Target does is different most clearly from Court of Appeal 104, which is PDF 211. And the reason for taking you straight here is that the Court of Appeal also quotes directly the first-tier tribunal's findings. So page 211, Court of Appeal 104. The Court of Appeal starts off by noting the upper tribunal's conclusion that the accounting entries in the loan accounts made by Target merely record the consequences of transfers that had taken place elsewhere. So it isn't like an ATP situation. And this was linked to the relevant findings of fact that the first tier had made, in particular at 42 and at 50. And if I could ask the court just to briefly remind itself of 42 and 50.
So sorry, was that the FTT, did you say?
So it's paragraph 104 of the Court of Appeal quotes directly from the FDT. So I'm simply inviting the court to read from that quote.
Yes, thank you. And so at 42, all the FTT is finding that the loan accounts are effectively ledgers, but the way in which they're populated, which the FTT set out in its factual findings at 50, is important because they'll be pre-populated by Target at the start of the day,
So on the day that Target is due to get all the money in, it pre-populates the loan account entries with what it's expecting to receive. Now, at that point, that clearly can't be a change in the legal financial situation. It cannot be the case that the borrower is now discharged, the borrower is treated as having paid that money, because no money has actually moved from the borrower's bank account. So nothing has happened, and yet the ledgers show, the ledgers record something that will happen later in the day. During the course of the day, the banks will transfer the money to Shawbrook's bank account, and there's a reconciliation at the end of the day, such that if Shawbrook's bank account has not actually received a particular payment, Target will go back through its ledgers and automatically strike out and reverse the payments that it put in at the start that didn't actually receive at the end of the day. And it cannot be the case. So the court was talking about examples of insolvency at various stages, but it cannot be the case that what the loan book says at the start of the day somehow discharges a borrower's obligation actually to go through and make the payment under the direct debit mandate. So in order for Target to be the same as ATP, Target would need to be saying, once those entries are made, that in of itself changes the legal and financial position. But that can't possibly be the case, because at that point, Shawbrook has received no money and the borrowers have made no payments. This is different to ATP, because in ATP, all that was happening was an employer was paying ATP a lump sum, and ATP was then doing the various distributions by the credit entries afterwards. Whereas here, nobody's giving Shawbrook a lump sum. Each separate individual borrower will be making each separate payment. And it's that payment, that actual payment made by the system that we were talking about in the morning involving banks and the Bank of England, that is the change. All that Target does by its loan accounts is just paperwork. And we know this because if that system that we discussed in the morning breaks down for whatever reason, Target reverses the paperwork. Very briefly, I just want to cover off the point that this is also different to the netting off that happened in FDR. Now, my learned friend hasn't expanded on this in his oral submissions, but the only point that I want to make is that on the facts in FDR, and I may simply just give a couple of references, we don't need to turn them up. The VAT Tribunal at 53 to 55, page 1205, set out the primary facts in relation to netting off. At 181, page 1230, the VAT Tribunal concluded that on the facts, the netting off in FDR involved a change in the legal and financial position, because that netting off actually extinguished the liability of an issuer. Now, as it so happens, HMRC disagrees with that piece, but that's water under the bridge, because those were the facts that were found. If that is so, then necessarily those factual findings put FDR as performing a similar role to BACS, because we're told by the first tier that netting off in fact extinguishes the liability. And just finally, for your note, there's some discussion of this in FDR, the Court of Appeal, paragraph 16, and actually I think it might be useful just to briefly turn this up. So it's page 863. Page 863 is the Court of Appeal in FDR, and it's the top of that page, between B and C, the sentence beginning, FDR proceeds to establish the net position of each client bank. And here, the Court of Appeal is telling us that FDR acts as a clearinghouse, so FDR acts like a sort of BACS entity when it performs its netting off function. So this isn't to do with a messaging argument, this is to do with the FDR netting off function. And as we know, a clearinghouse is essentially what BACS is doing. So if that is what FDR does, then it is in the same position vis-à-vis the netting off part of its function as BACS. And for the reasons we've already discussed, that sort of role is an exempt transfer. But that is not what Target does
because
here.
it transforms cross debts into a single debt of a different amount of money.
Exactly. If that is what FDR does, then that conclusion follows. But that is not on any view what Target's ledgers do, for the reasons I've already explained.
So you're not challenging that part of the FDR decision, but you are challenging paragraph 42, is that right? Effectively.
So paragraph 42 we're definitely challenging. That is in relation to a different piece. That's the BACS messaging issue. I'm instructed that HMRC doesn't agree with the finding as to what FDR actually did.
Yes.
But if FDR did what the Court of Appeal says it did, then the conclusion follows that netting off is exempt. So that's all I wanted to say about the ATP piece. My learned friend then says, oh, well, if we're not doing transactions concerning payments and transfers, then it must be debts. He didn't elaborate on that in his oral submissions, but all I want to say is, as the Court of Appeal pointed out at Court of Appeal paragraph 113, transactions concerning debts is a reference to dealing in debts. So, for example, transferring a debt instrument or assigning or novating an existing debt. On any view, my learned friend has not shown this court any authorities at all that support his argument in relation to debts. And we would say that the word debts and the notion of transactions concerning debts can't be interpreted so broadly as to undermine the boundaries for payments or transfers. So necessarily, the debts part of the exemption can't apply unless Target alters the legal and financial position of the parties to the underlying debt, which here it doesn't. So concerning debts cannot give my learned friend anything extra, anything broader, over and above transactions concerning payments and transfers. And in the last 25 minutes, what I'd like to do, please, is move on to the final piece, taxable debt collection, if I may. So there are two relevant authorities, MKG and AXA. My learned friend has already gone to MKG, so I don't need to go back to that. All that AXA is doing is applying the core findings in MKG. It's not doing anything else. So if I could ask you, please, to turn up AXA CJU, and please could we start off with paragraph 30, which is page 660. And at 30, the court starts off by noting that although the Article 13 exemptions are derogations from the general application of VAT and so are to be interpreted strictly, the term debt collection and factoring is to be interpreted broadly as it's an exception to such derogation. So we say that also underpins our point that debt collection here is functioning as a carve-out from the exemption. There isn't this notion of fence, the fence that my learned friend talked about, and two separate concepts going on here. And as we also know from AXA, the Court of Justice proceeds on the basis that one element of AXA's supply is an exempt payment transfer. And it then looks at AXA's overarching supply and says, well, even though you've established that one of your elements is payments and transfers, when we stand back and look at the whole supply, because AXA is doing other things such as record keeping the ledgers, working out who owes what and at what point in time. Is that holistic supply nevertheless a debt collection supply? Answer, yes. And the other point to note is AXA Court of Appeal, from the very start of that judgment, the Court of Appeal in AXA picks up on the way that the Court of Justice has dealt with AXA, and that is why it uses language of carve-out, because it accepts that there's a payment and transfer transaction. Is it nevertheless carved out because it is debt collection? So sticking with the Court of Justice in AXA, paragraph 31, financial transactions designed to obtain a pecuniary debt fall within the scope. At paragraph 33, the Court notes that the object of that service is intended to obtain the payment of debts. And also that Denplan frees its clients of tasks that it would otherwise have to do. At paragraph 34, the Court notes that debt collection is not limited to overdue debts, and that's obviously a key piece of the conclusion here. At 35, it's irrelevant that enforcement action isn't included. And at 36, the Court sets out what it is that Denplan does. It requests a direct debit transfer. It sends a client a statement of the sums received. It contacts defaulters. Now, pausing there, all of those are steps that Target does vis-à-vis Shawbrook, and all of those are over and above simply the making of a payment or transfer. And then it gives instructions to pay money on, and that last bit Target doesn't do, because if you remember in Denplan collected the money from the dentist, then paid it on. Here, Target simply initiates the process of the borrowers transferring to Shawbrook's bank. So what the Court of Justice is doing at 36 is it's listing out, on the assumption that one element of what Denplan is doing answers to the description of a payment or transfer. It is then listing out the totality of what Denplan does, and it says, well, when you look at this as a whole, this amounts to debt collection. Now, we say that nothing said in DPAS can be said to overrule AXA in relation to debt collection. And we already know, because we saw this earlier on, that the Advocate General in DPAS at paragraph 76 went on to say, well, if in fact you disagree with whatever I've said about payments and transfers, I'll now deal with debt collection. And it went on to apply the AXA approach. And all that the Court of Justice said in DPAS is that because it had decided the point on the prior payments transactions point, it didn't need to reply on the second question. So nothing that the Court of Justice said in DPAS can be said to in any way overrule what the Court of Justice has said in AXA. In any event, when the Court reviews what is said by the Court of Justice in AXA again, the Court will simply see that all that the Court of Justice was doing in AXA was applying the case law from the earlier case of MKG. It wasn't broadening it in any way. And in particular, this notion that debt collection didn't just apply to unpaid debts, but to debts as they fell due, first emanated from MKG. So there's nothing new in that. So AXA can't be said to have broadened any of the relevant principles wrongly in relation to debt collection. Now, if AXA is right in principle, my learned friend has to find some error in the first tier tribunal's conclusions and findings. And so if I could ask you please just to turn up the relevant parts of the decision. Well, actually, sorry, but before I do that, I just want to make some submissions in overview. So the first tier did not decide that Target was collecting debts simply by sending out its demands. So my learned friend says, oh, well, if Target is debt collecting, then all of a sudden every bank that ever makes a financial transaction 50% of the time must be debt collecting because you're simply issuing a demand for payment. But actually the first-tier tribunal held here that what Target does is far more than merely giving that instruction. It operates the ledgers, it contacts defaulters, it contacts borrowers, it reminds borrowers to pay. It does all of these technical aspects over and above merely the backs piece. And all of that is, of course, being paid for by Shawbrook. Put it another way, Shawbrook is not paying Target simply to fire off some direct debit instructions every month and do not a single thing more. Target does an awful lot more than that. The first tier also didn't hold at the level of principle that any and all settlement of a debt is debt collecting. Rather, it is precisely because of all the other aspects of the supply that Target is performing that the first-tier tribunal concluded that holistically, overall, the package was a debt collection supply. So if I can ask you please just to turn up page 271. And the key paragraphs are 1110 to 113. So this is the first-tier tribunal's decision in Target. Starting off at 110, the first tier concludes that the essence of what is being acquired and the main objective is the collection of debts as they fall due. And we say that's entirely open to the first tier to make that conclusion on the facts. And that is nothing more than a finding of fact. At 110 to 111, the first tier then sets out the significant number of activities that Target was carrying on for Shawbrook. And so we have, at 110, a significant number of activities are required, including the creation and operation of accounts, processing payments, dealing with customers, both immediately following the loan and where required at subsequent stages, providing statements, implementing procedures to deal with arrears. All of that is over and above merely sending out a direct debit instruction to backs.
But then she goes on to say that those don't affect the predominant nature of the supply as one of debt collection, whereas you seem to be saying that it was all that package viewed holistically that was debt collection.
Yes, so the first tier goes on, many of Target's activities can sensibly be regarded as part of a debt collection service. And so just to explain, what the first tier is rejecting here is as follows. My submission to the first tier, we were neutral on payments and transfers. But what I said was that if any element is a payment or transfer, that element is itself debt collecting. So I said you don't need to worry about what else is going on, because actually none of the elements should be exempt overall. So if I can just give another example by way of analogy, this court has recently decided the case in relation to e-newspapers, our e-newspapers books. There was a prior decision, judgment of the House of Lords, concerning whether a supply of books, so College of Estate Management, whether that was a supply of overarching education services or an exempt supply of books. So if you change the facts slightly, and so it's not hard copy books that's being supplied by College of Estate Management, it's e-books, the Court of Appeal would say, well, there isn't any weighing up exercise for us to do because e-books aren't zero rated in the first place, therefore none of your supply is zero rated. So where's the element that potentially makes us look at the supply holistically and decide that part of it may be zero rated? All that you're doing is making supplies of taxable or exempt, taxable books, exempt education services. So the point that I was trying to make here was to effectively say, well, if one aspect is payments and transfers, that aspect is of itself debt collecting. So why do we care about the whole? And what the first tier said, based on Mesto, was, no, that's not how to look at it. We have to stand back and look at everything that is being done and work out what the predominant element of the overall is. You can't simply knock out a little plank like that. The other point that I make on that is the Court of Appeal's difficulty with the debt collection argument concerned that first piece. Well, if you accept that something Target is doing answers to the name of payments or transfers, then we say that very thing is debt collecting. And that, of course, fed into my learned friend's view, oh, well, now all of a sudden, every payment is a collection of a debt. But if, in fact, you take the alternative approach, and our written case sets out these both separately, we're saying, okay, well, we accept that one little piece, one little element is exempt, payments and transfers. Now we have to stand back and look at the supply as a whole, as a whole, and work out what is the overarching supply. Now we have to take into account the entire, all of the aspects of the supply, and this feeds into what the first tier tribunal calls the Lavob type analysis. Stand back and look at everything holistically. At that point, the first tier tribunal looks at printing the statements, setting out the ledger, all the little aspects that clearly are not exempt, they're clearly taxable, pure administrative services, pure administrative elements, and the first tier says, well, look just in it around, all of that context, all of the circumstances, that entire body, that package is debt collecting.
So, but when Target was accounting for VAT, when Target was accounting for VAT, what did it treat? I mean, did it charge any VAT on the invoice it provided for its services to Shawbrook?
Please can I just check that for a moment? So it may be that my learned friend can help you with that, but we don't know because this was a request for clearance. So we weren't looking at Target's invoices and so on.
Because this gets to another something that's been bothering me, which is this interrelation of this debt collection point with the single supply or composite supply. Right. So as I understood it, what you just said was that your argument to the FTT was the instructions to BACS, it's not exempt because of DPAS and all those cases. If we're wrong on that, and it does look as if it falls within the exemption, then it's debt collecting. But if that's not debt collecting, then you have to look at that little bit of what they do as we have to step back holistically, look at it as a composite supply of all these different services, and even if that teeny bit is exempt, it's predominantly a supply of taxable services. What we don't know is whether Target claimed that all those other things were also exempt. But if they were, then you would say, well, they're clearly not, because they don't fall within any part of the exemption. Is that?
So I think that Target's argument is to say what we're doing is paying. This piece is payments and transfers. Now step back and look at everything as a whole. For some reason that we haven't quite got to the bottom of, the whole is payments and transfers because that's the main event.
Or if it's not then the predominant, for the purpose, for a CPP purpose, it's a predominantly exempt.
Yes, exactly,
supply.
exactly.
Right.
Now, if I can just pick up on that last point, Target cannot make a principal ancillary point good because of the first tier's factual findings at paragraph 42 that the ledger was also an important part of the supply. So it's first tier tribunal, paragraph 42. There's a finding of fact there that the ledger yes, the loan accounts are an integral part of the supply that the service that Target provides to Shawbrook. That's PDF 249. So if I can take this in stages, Target is relying on a execution, its BACS messaging argument. Alternatively, Target is relying on the effect of the ledgers. We get to debt collection, assuming that Target is right or on certainly the BACS point. At that stage, we say we'll stand back and look at the whole, and you have a choice as to whether to do the CPP principal or ancillary analysis. And I say, well, hang on, that's shut out here because Target would need to argue that its ledgers were ancillary, but the finding of fact by the first tier is that they're not ancillary. So it already can't do a pure principal is the BACS instruction, everything else is ancillary. So then we move on to what the first tier tribunal accepted as the correct approach, which is the LeVob type analysis. Stand back and look at everything. And at this stage, we say this is very similar to College of Estate Management. You've clearly got books in the middle that attract one tax treatment, 0 rated. Everything else is exempt education services. What is this overall? Is it a 0 rated supply of books? Or is it exempt? Or is it a little bit of both? And here, you would perform exactly the same exercise. Well, we have to accept that the BACS instruction, that little piece, is exempt. But now we stand back and we look at the totality of what Target is doing, because the one thing it is not doing is firing off direct debit instructions with nothing else. It's performing an entire piece, which the first tier sets out very clearly in its findings, which involve all sorts of contact with the debtors, every single thing from immediately after the principal sum is lent out to wrapping it up and discharging the security back to the debtors once the loan is fully paid off at the end. Every communication, every letter.
And that can only be treated as an exempt supply if it's treated as ancillary to the main event, which is the ledger, perhaps, if that's exempt, plus the BACS transfers.
And if you test the point this way, it would be a completely meaningless, because the other point is we have to view it from the perspective of the customer. So the customer in this case is Shawbrook. Shawbrook doesn't want Target to do nothing other than fire off some direct debit instructions. Shawbrook wants its entire loan books to be managed properly from start to finish. It needs the ledgers, it needs the statements, it needs Target to pick up the phone to defaulting borrowers. All of that is necessary, well over and above simply doing some BACS instructing. And when you recognise that, you're left with saying, well, it can't possibly be the case that none of that really matters. On any view, we know that the ledgers, which aren't exempt in their own right, are integral, are integrals. They can't be, as a matter of the factual findings, they can't be ancillary. We say this is a College of Estate Management case. Step back and look at what is going on. And when you step back and look at the totality of what Target is doing, the Court of Appeal's concern and my learned friend's submission, well, every instruction for a payment made by anyone, bank, whoever, is debt collecting, clearly falls away. Because if all that a bank does is credit an account to give its account holder a payment, it's not doing any of the rest of the package that Target is doing. It's simply doing that one singular change, and it's the package, the qualitative effect of that overall package which is what Shawbrook really wants, which distinguishes what Target is doing from merely your bank putting a credit. And Target actually set this out at one point in its written case. It used the phrase, the bank is blind. In a normal case where all your bank does is it credits an account, it's blind to the reasons. It doesn't care why it is crediting your account. The debt collection is completely different. Shawbrook cares, Target cares, and that's why it performs all the activities as a whole. And so the Court of Appeal's objection arises in relation to my argument that is now very secondary and I'm less keen on by the minute. But if I was to say, well, let's look at just that little element all on its own is debt collection, then the Court of Appeal says, well, hang on, is it really? Because all that's being done is an instructions being sent out to banks. So abandon that way of looking at it, and we've set this out in our written case. The second way is to look at the lot, look at everything that Target does, what qualitatively is going on there. And that is a holistic service of debt collection. And if I can make two more brief points, please. There's a very good discussion of single indivisible supplies and so on in the Advocate General's opinion in a more recent case called Frenetic Exito. And in interest of time, I won't actually take the court to it, but that's Authorities tab 16, PDF 787. And just very briefly, the Advocate General at paragraph 3 notes that the National Court has requested specific guidance on how to deal with this composite supply package, and it's Advocate General Cocotte who is incredibly experienced, particularly in relation to that. She sets out the legal principles broadly from paragraph 14 of her opinion, all the way through, so far as they're relevant here, to paragraph 35. And when you look at the court's judgment in large part expressly agrees with a lot of the sections in her opinion. And that sets out this notion of take a step back, look at the whole. Your overarching supply may not necessarily be what one of those elements is, but it may be something different. It may be a broader sui generis supply. And that, we say, feeds in, and we said this in our written case, to the way that Byron and the College of State Management looked at it, this concept of an overarching supply. And there's one last point, and so obviously the first tier's factual findings that you'll see when you look again at 110 through to 113 bring in everything else Target does. And there's one last point, if I may, which is management of credit. The way that we put this argument is, it doesn't matter to us whether you want to call the supply debt collecting or management of credit or loan account administration or some hybrid of all three, because all of those three things are taxable. For Target to win, Target has to persuade this tribunal that what it is doing is an overarching supply of something that is exempt. We don't need to be precise in identifying exactly the nature of this taxable service. It can be a hybrid of all three. In relation to what we say is management of credit, there is no case law precisely on this point, so there isn't a European case. We say it should take on its normal commercial meaning. Management can't be the stages prior to loan drawdown, because that's negotiation. So management has to be something that is done after loan drawdown. And when you think about what management of credit means commercially, it does overlap with some of the tasks that Target does. So monitoring customer payments, collection, enabling borrowers to pay, setting up that facility, giving them notifications and reminders and so on. Yes, you may say management of credit includes other things, such as taking a holistic look at the entirety of Shawbrook's lending books, which Target doesn't do. but some of the activities that Target does do falls into management of credit, or it can be described as debt collecting. And the point on management of credit is, on any view, that isn't being done by the person granting the credit. So whichever way you slice it, it's taxable.
But this isn't really a carve-out in the same way as debt collection. It's more an aid to construing what's in D. You say it mustn't include what's clearly excluded from
elsewhere.
B. Yeah.
But I would also add that, of course, management of credit by anyone was included.
Yes, I understand that point.
Until it was specifically taken out. So we would say the legislator has made a choice that if you are managing credit for someone and you are not the grantor, what you are doing is taxable. If I may just check there's nothing else. So unless there are any further questions, those are our submissions.
No, thank you very much indeed, Ms. McCarthy. Well, we are grateful to counsel for giving us a very good argument on both sides. We'll now consider what's been said and let you have our judgment in due course.
My Lord, would the court be assisted by a reply from me?
Is there anything particular you want to reply on?
Well, in terms of the factual situation concerning BACS...
Sorry?
My Lord, there is certainly a factual matter concerning BACS, which it may be helpful for me to point out. It's in the bundle.
Yes, yes.
And it's to be found at page electronic. There's a section in electronic at electronic page 1519, but specifically at page 1534. And much appears to depend on, for my learned friend's approach, to making sense of the fact that BACS is exempt, that according to the Crown, BACS's major function is netting off. We respond factually by saying that that is not any part of BACS's function, and what appears at 1534 and following, just a couple of pages, indicates that BACS, what BACS does is very much messaging based, and specifically, as you can see from 128 on electronic page 134, second paragraph, it is described as a clearinghouse scheme, but there are many types of clearinghouse. And if you look at the second paragraph, each member has direct access to the BACS system and will supply BACS with credit and debit instructions as computer data input data for processing. Members may also sponsor their non-personal customers, i.e. non-member banks and building societies and corporate customers, to submit their own input data to BACS. So my understanding is that Shawbrook is a member, it sponsors Target. So Target is within the pale in terms of those who can speak to BACS. And if one then turns to the next...
Target isn't a sponsored customer of Shawbrook, is it?
It's not a customer, no, but it communicates with BACS under Shawbrook's umbrella, my lord.
Right, but this passage that you've shown us isn't talking about that sort of arrangement. It's talking about arrangements where you have, as I understand it, a bank who sponsors one of their customers in some way to have access to the BACS.
I don't... Yes, my lord is right.
So this doesn't seem to have anything to do with the arrangement between Shawbrook and Target.
Well, we never went into the evidence on this point, and this is the best I can do, but it's clear that a Target do communicate on the bank's behalf with BACS. I can't go further than what's on the page, but looking across to what BACS does, and if we look at 1535, one sees there a description of I won't read it aloud, but under paras 129 to 140, it describes the cycle the 3-day cycle. And the sense of that in my submission is that messages are received, acted upon by banks, and just in the last few lines above the footnote, which starts European Central Bank, there's this. However, the debiting and crediting of accounts may not occur simultaneously during day 3 and is left to the discretion of members. The interbank obligations which arise in BACS are settled at the Bank of England on a multilateral net basis on day 3 of the processing cycle. This settlement occurs at 9:30 a.m. daily through the posting of the multilateral net amounts directly to the settlement accounts using CHAPS. So it would be entirely wrong for the court to factor into its decision any impression that BACS performs an FDR-style netting off stage. In any event, FDR netting off was of a purely contractual nature. The clearers who appointed it simply gave it the power to strike a figure. That still left, of course, FDR with the obligation to send the BACS messages to move the balance. The picture that emerges from this page of the Banking Encyclopedia is entirely consistent with our analysis that BACS simply sends the messages per paragraph 42 Lord Justice laws, and it does nothing else, and the banks simply act on those messages. The fact that the Bank of England uses a different messaging system only underlines our point that since money only moves by entries, and entries only respond to messages, the whole process is of a piece, and there is an indissoluble link between the messaging and the changing of the entries, and one cannot, as the Crown has endeavoured to do, separate the two processes. And over the page there are the diagrams with which the court is familiar, and a quote from Mr. Justice Henderson. So that was the factual point. If the court would be assisted by anything else, but if not, I will not trouble.
I think we've had very full submissions on the law.
Very well.
Thank you. Very well. Well, the court will adjourn. Thank you.